All rise. Hear ye, Court of Appeals for the First District of Texas, now in session. Pursuant to the government, United States Constitution and this honorable court.
Please be seated. Welcome to the First Court of Appeals. My name is Justice Goodman, and to my left is Justice Rivas Malloy, and to my right is Justice Landau. We're here today to hear case number 0119-00487-CR, Lindapone Van Prassem versus the State of Texas. And appearing for the appellant is Mr. Hochlau?
Yes, sir.
Okay. And for the state, Mr. Stott. My understanding is that you would like to have 20 minutes on each side?
Yes, sir.
And the appellant has asked to reserve 10 minutes for a vote.
That is correct.
Okay. If there's nothing further, then I'll ask the appellant to proceed.
Thank you. May it please the court. This is a case of basically a volume practice lawyer that got himself involved in a capital murder representation that he had no business being a part of. And over the course of 3 years representing a client, he filed nothing. No subpoena applications, no motions, no requests for anything, no requests for discovery, no requests for extraneous notice. He performed, depending on what part of his testimony you believe, either no investigation or such a small investigation that it was tantamount to no investigation. He never sought counsel from any more seasoned lawyer that had more experience with capital murders. He never sought expert assistance in any way. And this is really just the backdrop of and context of his representation. And the state's argument throughout its brief is that this court is effectively not empowered to address this because the trial court made factual findings, and these factual findings are required deference. And because it's an abuse of discretion standard, essentially this court is not in a position to question those. I would dispute a lot of that, but to start with, I would submit that the majority of the evidence before you really has nothing to do with credibility. It has transcripts. You have the transcript of the PSI hearing itself. You have the transcripts from the co-defendants' trials. You have transcripts from the defendant, appellant, her police interrogations. None of this can be challenged. This is not dependent upon whether the trial court believed Robert Valles or believed Lindapone Van Prassem. And what I think both the state and the trial court got mixed up in was sort of devolving into a sufficiency issue, where they started analyzing, did they believe the defendant was guilty or not? But that's not the question. The question is, what was she saying to the police? What was she saying to her lawyer? What was she saying to the judge? What was she saying to the PSI writer? What was she saying to the prosecutor? And that is basically irrefutable. It is incontrovertible that in her initial police statement, she denied scienter. She said, I was a part of this kidnapping, but I did not understand that kidnapping was happening.
Mr. Hochlau, I agree that this may not turn on credibility ultimately, perhaps, but I need to understand what is left after the admonishments at the guilty plea. She says she initials, and I'm looking at page 41 of the record, joined by my counsel, I state I understand the foregoing admonishments, and I am aware of the consequences of my plea. I am mentally competent to stand trial, and my plea is freely and voluntarily made. And skipping down a bit, I have read the indictment, and I committed each and every element alleged. I understand that she may not, as a functional matter, have understood what she was pleading to, but is she not charged, as a matter of law, with these admonishments that she initialed?
I would say no, Your Honor,
Okay.
in the sense that she's been misinformed. She has every reason to believe when she's signing this that nothing in those admonishments, nothing in her judicial confession is inconsistent with anything else she said before. And she's given these statements over and over again, and her attorney has approved of them as if she was confessing to all the elements. And so when she changes her plea, essentially, from telling the police officer, I'm innocent, to putting in writing before the judge, I'm guilty, she is not changing the substance of her version of events. She's merely stating that I am making the statement of guilt, but I do not appreciate what the distinction is. I do not appreciate the significance of a judicial confession. And you know, one of the things about the trial court's findings is that it suggests that she didn't understand what offense she was pleading guilty to. That's not the issue. The issue is that she does not understand what a judicial confession, how that is interpreted in the courts of law. And the failure of Mr. Valles to clarify that for her is the critical part of our appeal.
And this has to do with the scienter or mens rea issue?
Yes, sir.
That basically she said she did not have the intention to commit the crime,
Yes,
and
sir.
therefore lacked element of the crime, but in the judicial confession, she said she was admitting to all the elements of the crime. But so there's a
But respectfully, Your Honor,
Yes.
she's not charged with knowing what the definition, the legal definition of intentionally and knowingly is. And to the extent that she is saying, I did participate, I knew I was there at the house, I knew I was driving a car away with the complainant inside, she could be easily understanding that to be, I did this intentionally, when in point of fact, she's not saying, I intentionally abducted anybody.
Here's a follow-up question. If you take the admonishments at their word and you say no, but as I understand your argument, no, this judicial confession doesn't work because she didn't really understand it. Aren't you really saying, though, that question is one that the trial court was doing a credibility determination on? Or aren't we, in effect, bound
Yes.
by that?
That part I do concede. However, take in context that the trial court finds Robert Valles credible and says that I believe Robert Valles' description of the communications between attorney and client. And Robert Valles concedes. We never had that conversation. In fact, I never even registered that there was a disconnect in the scienter. And given that, we can draw a straight line from her police interviews all the way through to her PSI and be very clear that there was never a moment in between where the client was admonished, hey, what you're saying is not a confession, it is a non-confession. And this trial court is going to view your plea of guilty much more harshly for the fact that you're not confessing. You're saying on the one hand you're confessing, on the other hand you're not. And we need to get this straight. We need to get this straight before you enter your plea of guilty.
No, I think it was the
Oh.
answer to when Justice Landa asked the question. Thank you, Justice Goodman.
My point, turning back, I think the majority of the evidence does not rely on a credibility assessment. But again, to the point that it does, even Valles confirms this absence of any communication about mens rea. And I'm going to sit down in just one moment here, but I want to sort of ask the state before they come up here. In my brief, I put forward sort of three basically indisputable contentions. One is that she denied scienter, two is that Bias should have known she was denying scienter, and three is that they never had a conversation about it. To the state's brief, they answer, well, this is all about credibility, and it doesn't matter what the defense says is incontrovertible. But my question to the state is, if those three things are true, does that amount to ineffective assistance of counsel? Because they don't address it, just as the trial court didn't address it.
Can I ask you a question before you finish up here? And you can save your response for when you come back. But your request to this court is to reverse and remand for a new trial, including a new guilt innocence phase?
Yes, sir.
And that could open your client up to other charges besides the charge she confessed to?
Absolutely.
Okay.
Absolutely.
May it please the court. The capital murder charge against the appellant in this case was dismissed when she pleaded guilty to what is a parolable offense. Her two co-defendants were convicted by juries of capital murder without the possibility of parole. The appellant was the architect of a substantial drug trade, and this scheme resulted in the deaths of two people. She was intelligent enough to earn admission to the University of Texas and capable enough to hold down a job as an executive assistant to the CEO of an offshore drilling company for 2 years. The trial court noted as much at the motion for new trial, finding specifically that it was incredible that the claim that her plea is the claim that her plea is involuntary, and noting that she was able to not only survive but truly navigate the sophisticated and dangerous waters of the Houston narcotics underworld. The court, who observed her in person at her PSI, noted much the same thing. They said that she was basically leading the charge to have someone kidnapped and ultimately killed. That's from the record of the PSI. The appellant is now asking this court to disregard the statements and findings of the two judges who witnessed the appellant in person or via closed-circuit television, and who evaluated that appellant's credibility, and to essentially review this case de novo. And I do want to take a moment to address what defense counsel was asking here just a moment ago. It is true that the appellant denied scienter or denied the required mental state for the crime throughout many of her interviews. However, two factors are left out of that. One, as Justice Landau noted earlier, she did make the judicial confession, and that's a sworn statement. And two, in addition to making that sworn statement, she also, and trial counsel noted this fact, had already made a statement to the police before trial counsel signed on to that case. So he was saddled to some extent with this prior statement. And his opinion, according to his testimony, was that statement amounted to an admission of all the elements of the crime. So he was working within a framework that had already taken into account what was, in his judgment, a confession. Whether or not she was admitting to scienter in all of her interviews, he believed that the state could prove beyond a reasonable doubt her guilt based on that statement and the supporting evidence that they had. The assertion that they had never talked about scienter is a little bit muddier than the appellant would make out. He did not recall, and as counsel has pointed out, there were a number of things he didn't recall because he didn't have his file folder with him.
He didn't keep a file, did he?
He couldn't locate the file, was the testimony, and the trial court held that although he couldn't locate it, it did not mean that he never had the trial file. Certainly opinions may differ on that. I think the appellant's brief suggests that there wasn't a file, but there's no specific testimony that there was never a file. He just said that in the course of an office move and some personnel changes, he couldn't find that file. And so many of the statements that are taken as affirmatively negative by the appellant are actually inconclusive. They're statements where the trial counsel testified that he did not recall or he did not know. And so if we were to look at the communication that we do know, we can turn to the evidence that showed that on a number of occasions he did visit the Harris County Jail, not
Mr.
between...
Stott,
Yes,
I guess
ma'am.
I don't disagree that he visited the jail, but that's not really the contention in this case. I mean, you can visit the jail 20 times, but if you never talk about something pretty important, the only issue in her case, the mens rea, I mean, that's the thing, not the number of visits or the quantity or other qualities.
Respectfully, I would say it goes to the overall quality of communication that they had, and it was a factor that the trial court took into consideration when it evaluated the thoroughness of the communication.
How are we to understand what happened at the punishment hearing, where much to her own detriment, she continues to deny that she is responsible for the offense?
I think on the one hand, that's consistent with her other statements where some of her other statements where she's confronted with consequences for her actions. When it was going to result in the dismissal of a capital murder, she was happy to sign that judicial confession and did sign that judicial confession.
Right.
When she believed it was to her advantage, she
But it's not to her
minimized.
advantage to go in there that way and make those assertions. I mean, that actually makes some sense that she at least didn't understand what had happened because of how she conducted herself at punishment.
So I don't think she would be the first or the last defendant who, when faced in front of a judge, minimized the level of their guilt or conduct. And the trial court was allowed to compare that evidence to the evidence of her judicial confession to find incredible the statements that she made both in front of or at the motion for new trial in front of Judge Smith, and to take into account the record from the PSI hearing and to glean from that she was not credible when she said she did not have the required scienter. And so we're faced with what level of deference the trial court is to be given. The reviewing court should defer to the trial court unless the trial court's claim is unreasonable and has no basis. And here there is a basis. The basis is that judicial confession, which was signed in front of a clerk, in front of a judge. You had Judge Belinda Hill, who oversaw the plea, who believed that she was pleading freely and voluntarily, and you also had the same in effect from Judge Clark and then later Judge Smith.
Mr. Stott, going beyond, that issue addresses the scienter, her understanding of what she was pleading to, but going beyond that and moving on to the sentencing hearing, was it deficient for Mr. Vargas not to have met with the defendant and the appellant in this case to explain to her what the process would be at the punishment phase and the consequences of her not admitting responsibility for the offense to which she pled guilty during the sentencing phase?
Well, respectfully, that would be an assumption that there was no conversation at any other time. Trial counsel did talk about the ordinary admonishments and discussions that he had during the course of his meetings with clients over the course of his career and the routines that he had. And he would have also had an opportunity to meet with her when she was in court, immediately after she pled guilty or before she went on. So there's no affirmative evidence that that conversation did not happen. He did not recall it, correct, and there was not a meeting at the jail to discuss it, but that doesn't mean that it didn't happen. And on the absence of that record, the state would suggest that Judge Smith's evaluation of the credibility and quality would control.
Was it not evident, given her testimony, that she did not understand and
If
had
we-
not communicated with her counsel about the process, the sentencing phase process?
If we are to believe her testimony, and respectfully, again, her testimony varies, and at the beginning of the PSI hearing, even trial counsel knew the number of times that her story had varied, because he took her through each of the times she had contradicted herself between the PSI report and the prior interview with the police to clarify those contradictions. It's not unusual that her statements contradict each other according to what is most convenient at the time, which again, if anything, supports Judge Smith's findings that she was not a credible witness. Mandy Miller, the expert that was brought during the motion for new trial hearing, admitted during that hearing that it was in fact a positive thing that the trial counsel was able to secure the dismissal of a capital murder charge. And here, when we talk about the effectiveness of his representation, I think we have to take that into account. Here's somebody who's charged with aggravated kidnapping and capital murder. The capital murder charge is dropped. They're not heading to trial, and he accomplishes what is highly effective and not particularly common advocacy when he gets that capital murder charge dismissed.
Mr. Stotts, can I ask you the same question that I asked the counsel for the appellant, which is, the appellant has requested this court to reverse and remand for a new trial, including a new guilt-innocence phase, and my understanding from his response is that that could include the capital murder charge that was dropped as part of the plea bargain. Is it your position that the state opposes that outcome?
Certainly the state opposes the reversal here of the trial court's denial of the motion for new trial. And our position would be that the appellant pled knowingly and voluntarily, that she understood the full offense just as she swore to in the judicial confession, and that counsel, far from delivering ineffective assistance, was in fact highly effective. And the result of reversing for ineffective assistance could in fact be that, like her two co-defendants, she ends up convicted by a jury for capital murder, which would seem to be the opposite of effective assistance in the overall scheme of things. If there are no further questions, the state would yield the remainder of our time. Thank you.
There's a couple points that I just want to dispute that the state brought to light just there. And the first is that the state seemed to say that when Valles came into the case, the defendant had already given a statement to the police, which is true. That is true. But this is a lengthy statement, 5 hours long. He didn't actually receive that statement or have the ability to review that statement. I think at the time of this second arranged interrogation on September 29th, he had access to an offense report that covered a description of that statement, but no more. And even that he only received, I think, 3 days before that second arranged interrogation. So he didn't know what he was saddled with. And I would submit that he, even as Ms. Van Brassel was entering her guilty plea, he still didn't know what she had saddled him with, and it really was never an issue in his head. Now, the second point is that, to your question, Justice Rivas-Malloy, regarding punishment, and the jail records, the trial court found the jail records to be credible. And I would submit that perhaps they don't technically qualify as incontrovertible evidence, but they're darn close. And they clearly show that there was no visitation between the plea and the PSI hearing. And I would submit again, it's evident from her testimony that she does not understand that by saying, I didn't know a kidnapping was happening, she doesn't understand that she's being counterproductive. And she's taking the witness stand believing in her mind that she's owning more than what she did. She believes, I'm pleading guilty, I'm giving you my guilty plea, even though I didn't really do it all. Right? And in the trial court's mind, in the prosecutor's mind, and in the PSI writer's mind, even in the police officer's mind, what she's doing is just denying responsibility. And the only person involved in this mess that didn't like sort of crystallize the denial was Robert Valadez. And that's evident in his testimony. When asked, did she, in each of her various statements, acknowledge each and every element? At first he says, yes, she did. Yes, she did. Because that was what he recollected. But that's not true. He's just wrong about that part. And then once he was confronted with the fact that actually she was denying Sienta the whole time, then he recognizes that in the middle of the motion for new trial hearing. But not until then.
One question I had, the way she phrases her denial, some of it is, I didn't do it. And I was wondering how much of that is a lack of understanding of party liability? Like she thinks because she didn't fire the gun, she's not responsible, or she was sort of part of the car that engaged in the kidnapping, but she didn't orchestrate the kidnapping maybe. It's hard to read kind of between the lines of her denial what she's denying.
For sure. And I wouldn't dispute that a bit. What I would point to the court is in closing arguments, the state basically acknowledges she was neither a principal nor a party, and that there's no evidence that she ever intended, and I'm speaking about the capital murder, I'm not speaking about the aggravated kidnapping, but that she never had any intent to see anybody killed, and that they don't believe she did. And this is important because what that leaves is her culpability potentially as a co-conspirator, right? Which, again, Mr. Valles was asked, can you just articulate what the difference is between a co-conspirator and a party? And he had no earthly idea. And I bring this to the court, I think there's a lot of attorneys that probably off the top couldn't distinguish a party from a co-conspirator. But my point is, in addition to him failing to identify even the sort of rudimentary mens rea issue of, is she aware that there's a kidnapping or not, right? This mens rea issue is tricky, and it required a great deal of attention and thought and discussion.
But those are complicated legal concepts. How much was he supposed to explain, and honestly, to a lay person who is not legally trained? I mean, just the word scienter and mens rea is complicated, and we can debate about what that means and write briefs a length of it. What was the level of communication that was required for us to find the representation was not deficient?
I would submit in a capital murder case where co-conspirators are common and frequent, he needed to know that. But even to your point, Justice, he didn't even know the difference between knowingly or not knowingly, much less the distinctions where we get into very complicated issues that are really important. They're really important. But I take your point. My answer back to you is, he didn't even know, he didn't even scratch the surface of it, much less get to the heart of it. Now, there's a few just sort of nuggets that every time you go back and read the record again, getting ready, and there's just a couple things that I didn't mention in the brief that I wanted to cover. One is, I mentioned in the brief a couple places where the trial court is sort of hedging on the defendant's denials of scienter, because the trial court never really comes out and says that appellant repeatedly denies scienter. But if you look at findings of fact 89 and 105, 89 basically mentions that Valles was concerned that his client's denials wouldn't be believed by the jury, and that's why he recommended a guilty plea. Well, implicit in that is that he must have understood there were denials, right? And which is implicit in the trial court's understanding that there were denials, right? Now, I think that goes completely contrary to what Valles actually said. Valles said he never realized that there was a denial. He never realized that there wasn't a discrepancy. But, yes, sir?
Can I ask you, Mr. Hotcliffe, do you think that those repeated denials basically were an invocation of the right to trial by jury on the part of the defendant?
Well, and this is another point that I'm glad you brought up. I think in her mind, she was expecting that there would be a jury trial, or at least there was a likelihood of a jury trial. She had no idea. This goes to her credibility, right? And I took actually great pains in the briefing, despite what the state says, to avoid issues where it was a specific credibility conflict between Valles and Van Prassel.
But I think it becomes, again, a credibility issue because in this admonishment and the judicial confession, it says, you know, I understand I don't get a trial anymore because I'm pleading guilty.
Well, I don't think there was any question at the time of her plea that she understood there would not be a jury trial.
Okay.
I'm not disputing that.
Okay.
I guess I took Justice Goodman's question to be, at the time that she's doing her police interrogation, does she expect that there's going to be a plea? Does she expect that there's going to be a trial? And I think at that point, in her mind, she's just thinking, I'm being cooperative, I'm helping myself, and I'm helping the police. And I don't think there's a crystallization in her mind as to where this ends up resolving. But I would note that she files 6 months before her plea a speedy trial pro se motion, right? Very specifically saying, I want my trial, right? And there's a couple of trial court findings that suggest she never gave any indication that she wanted a trial. Well, that's just not true. And this is sort of irrefutable evidence that's in the clerk's record.
Well, okay, just to make sure I understand. I mean, eventually she gave up that right by pleading guilty. The question is just whether that guilty plea was voluntary.
That is true. That is intelligently made and voluntary. But I guess my point is that the trial court is saying there is no evidence in the record that she ever wanted a trial. In point of fact, there is. The last point I'll make it very quickly, is finding of fact 104, which is where the trial court finds credible Valles' admonishment at the PSI hearing, be truthful, be sincere, and accept responsibility. And the tone of that and the description of that by the trial court's writing is that that's somehow sufficient, that that's enough counsel to understand the admonishments, to have understood all the rights that you're waiving, to have understood that when you pled guilty to all of the elements, and you understood the mens rea, and you understood the scienter and all of it. And I would just say that is woefully not sufficient counsel.
What do you say in response to the state's argument that it was highly efficient representation and that she got the capital murder charge dismissed?
Well, I agree with Ms. Miller that it's certainly better to have that dismissed than not. But she has to be aware of what it is she is pleading guilty to. And regardless of what it is that she's avoided, that plea of guilty has to be intelligently made with her understanding exactly what that judicial confession is going to mean, not just in her mind, but to the prosecutor and to the judge. And she didn't.
Thank you, Mr. Hotcliffe.
Thank you.
That concludes the session, and with that, case number 0119000487CR, Lindapone Van Prassel versus the State of Texas, has been submitted to the First Court of Appeals. I thank you.
All rise.